Good morning, everyone. Thank you for coming back to part 2 of Avoiding Common Pitfalls, What You Need to Know to Succeed as an Electrical Construction Contractor. With us this morning again is John Greenhall and George Pallas, and I think, not sure who's up first, sorry.
Oh, John.
I am. John
Greenhall.
Good morning, everybody. There was some confusion yesterday with regard to the polling because we did not keep the slide up very quickly. If you look in your, or very long, I should say, if you look at the screen, there is a button that says chat. Under that, you'll see a text telling you what to text to the to Cohen Segley is 527, and that, or I'm sorry, boy, starting off well. Please text Cohen Segley is 527 to 22333 if you want to participate. That's Cohen Segley is 527 to 22333. All right, with that said, let's try to move forward. Yesterday, we spoke about basic contract ideas such as risk allocation, change orders, and releases. And today we're going to go through some other critical contract provisions, as well as claims and project documentation. We're going to try and take a break at around 10 o'clock and give everybody a chance to walk around and step away from their computers. With that said, let's start on other critical contract provisions. So as I mentioned yesterday, there are a number of critical provisions in every contract. Some of the ones that we focus on are listed here on this screen. We're going to be looking at items like scope, payment terms, change orders, schedule requirements, liquidated damages, coordination responsibility, notice, etc. And if you have any questions, as we did yesterday, please feel free to type them into the question box, and George and I will try to answer them during the presentation. If we're not, we'll save some time at the end for your questions. So here are 12 clauses to look out for that we're going to be discussing this morning. Pay if paid clauses, termination for convenience clauses, no damage for delay, the non-mutual waiver of consequential damages, the waiver of any payment act, such as the New Jersey Prompt Payment Act, responsibility for unknown, such as subsurface, a non-mutual waiver of subrogation, harsh notice provisions, incorporation by reference, the choice of arbitration or litigation, and an unfriendly jurisdiction for dispute resolution. So let's first talk about the scope of work. Generally, you believe that your scope is your scope. You understand that you're supposed to do what's in the plans and specs with regard to electrical. This becomes more complicated as the project gets larger and scope is divided among various electrical contractors, or if you are a sub to a sub and it becomes that you're doing only a portion of the work that's being requested. So it's important to look at your documents, make sure that the scope is adequately defined, and read the language. Many times the provision with regard to scope will say that the work includes anything that may be contained in any other specification on any drawing, and anything reasonably inferable from those plans and specs. In saying that, the words reasonably inferable are extremely important. It is what a common person, your reasonable man, would determine what is included in your scope. So for example, if you have to, if there's going to be a dishwasher in a particular unit and there's no electrical behind it, it's reasonably inferable that you may have to put an electrical outlet behind that dishwasher, even though it's not shown on the plans and specs. Does that mean that you automatically go out and put that in without talking to anybody? No, but what it means is you need to submit an RFI, make sure that everybody is on the same page with regard to where that dishwasher is going to be plugged in. One of the other issues that arise with scope is sometimes the plans and the specs don't match up. So in that circumstance, which takes precedence? 99% of the time, the contract is going to say, whichever is worse for you is the one that takes precedence. So it's usually the more expensive, the more stringent, etc. Other times it does create the contract contains a list of preference or precedence. So it'll say things like the drawings take precedence over the specs, for example. You need to make sure that you have covered everything that are in both, because all that does is lead to issues. If there is an issue that you see, the contracts all require that you notify whoever you have a contract with that there seems to be a discrepancy. Don't just choose one or the other, ask about it. The other aspect with regard to the scope of work is the issue with what is called a turnkey project. On a turnkey project, you're basically guaranteeing the drawings. You're saying, I'm going to provide whatever is in the drawings, and I'm going to have it so that you can turn a key at the start of the occupation of the project, and everything will work perfectly. When you see words like turnkey or all of the work shown on the drawings will end with a complete project, that is saying that you're guaranteeing the drawings. Things like that need to be removed. You are not the designer. You are the contractor. The designer, whether it be an architect or an electrical engineer, should be the one guaranteeing the drawings. The other part of scope of work are guaranteeing previous work. Almost every contract contains a provision that requires you to investigate any work that was done prior to you performing work in that area. That means that you have to perform a reasonable inspection. You're not required to dig down, do testing, anything of that nature. But if it's very clear, for example, that the floor is unlevel and you need to put in an electrical box at a certain height and you can't do it because the floor is unlevel, that is something that you need to raise with the powers that be. So the plans and specifications, as you know, is a list of what is included. Under the law, the owner impliedly warrants that whatever is in the plans and specs is going to end up working. So if everybody builds what's in the plans and specs, at the end of the day, they have a completed project. But what happens if there's an issue where you have done all of your work, everybody else has done all their work, and yet the building fails and doesn't stand up? In that instant, it's not your responsibility to make it work. It is the owner's responsibility to get the architect to revise the project documents to make sure that it leads to a completed and proper project. With regard to any exclusions and clarifications within your bid, make sure that that's in there. We have seen numerous cases where the electrical contractor, for example, doesn't include concrete pads or rock removal or whatever in their proposal. And then they get their contract, they don't review it carefully, they sign it. Those exclusions are no longer available to you. So make sure that they are properly listed. And if you get a contract that does not have them properly listed, don't sign it, raise the issue, and discuss that with your client. With regard to public work, if you have questions about your scope of work on a public job, that needs to be raised immediately pre-bid or as soon as it's discovered. Otherwise, you're assumed to have properly bid the project and knowingly accepted any errors in the plans or specifications. So one of the things we were talking about yesterday and just now is the idea of the contract not containing all of your bid proposal. That's through what is called an integration clause. As you can see by the clause on the screen now, that the signing of your contract will supersede all proposals, correspondence, and oral agreements. We've had situations where people have shook hands on a porch and said, yeah, that's what our scope is. And then they sign the contract and it doesn't say what was said on that porch. It is if it does not exist. In addition, there are issues with incorporation by reference. What that does, and this again is in every subcontract, the contractor is saying that if there is a prime contract, the terms and conditions of that prime contract are part of this subcontract. So if you sign an agreement without knowing what is in that prime contract, you may be buying a boatload of additional job requirements, even though you did not know they existed. So before signing any contract as a subcontractor, make sure that you have received a copy of the full prime contract. They can redact the pricing, but if you don't get a copy of it, you're going to be sorry at the end of the day because the GC is going to be relying on it, especially with issues such as notice, which is a big part of what the prime contract pushes down to subcontractors. Other than notice, and we've seen situations where the prime contract requires notice within 24 hours, for example. There are issues with regard to dispute resolution. So, for example, if you do not want to have an arbitration and the prime contract says everything goes through arbitration and your contract is silent, that arbitration is going to bind you and you're going to have to participate in that arbitration. The other thing that's near and dear to all of your hearts is the payment terms. Some contracts have extremely long payment terms, and as a subcontractor, you're going to be waiting till the end of that payment period, plus usually 7 to 30 more days before you get payment. The same goes with retention provisions, and we've seen as high as 20% in some jurisdictions. So the contract documents are usually listed in the document. Make sure before signing the contract that you have everything that is listed in this paragraph. This is from, what's on your screen is from the AIA contracts. If there's a reference, as there is here, to supplementary conditions, make sure you get them. Those will be amending the general conditions, and those general conditions may amend the base contract. So everything is important. And as you can see in this provision also, your proposal is not included as a contract document. As such, we always tell our clients, all our subcontractor clients, to either get their proposal as an exhibit to the contract, or if the GC is unwilling to do that, make sure that you have everything that's in your proposal written into the contract. And that goes that's very important with regard to your exclusions and clarifications. So commencement, you would think that this is a very straightforward provision. This is when we're going to start. But if you look carefully, the references to a notice to proceed. We have had situations where contractors have come to us and said, we haven't gotten a notice to proceed in 6 months. What should we be doing? The answer to that, if you haven't revised this provision, would be to have it so that you can ask for a change order relating to the failure to provide the notice to proceed in a timely manner. I prefer revising this language to say that if the notice to proceed is not issued within 30 days, 60 days, whatever you're comfortable with, that the schedules are extended for each day, and that there may be extended general condition costs. And here's an example of that provision. Finish time also is one that is more complicated than it appears. As you can see in the standard AIA form, the contractor shall achieve substantial completion of the entire work within a certain number of days from the date of commencement. Many times owners change this to final completion. There's a big difference between substantial and final completion. Substantial being that it's basically done to the point where the owner can use the project, where final completion is everything is done. You are out the door. There's no more punch list. All of the certificates of occupancy, temporary and final, have been given, and you're done. That's final completion. We'll talk about liquidated damages in a little while, but you should make sure that any liquidated damages are tied to substantial completion, which is more in your control than final completion, simply because once you're done at substantial completion, the owner may be in your way, may be moving in, etc. So the key here is the terms substantial completion. Also, many owners are defining substantial completion to be the same as final completion. Make sure that if you see any provision that requires a full and final certificate of occupancy as part of substantial completion, that be revised to include temporary certificates of occupancy. We had one client who needed to reach final completion to avoid a $4 million one-day liquidated damage. And a court ruled that since the township did not provide us with a certificate of occupancy, we did not satisfy the requirements of the contract and awarded the other side $4 million. So it needs to be very carefully reviewed to make sure that your substantial completion is something that can be reached. Allowances, the biggest issue with allowances are defining the work and notice when the allowance is going to be reached. Surprisingly, many contracts don't discuss how an allowance is going to be increased. So, for example, you have an allowance of $500,000 for lighting, and you now are purchasing things that appear to go over that $500,000. When do you put them on notice? That is not identified anywhere. You also would need a change order to go over that allowance. So be careful on how you deal with allowances. The earlier, the better, in my opinion. Now we're going to talk about payment, which obviously is important. Here's your standard progress payment provision. Under these provisions, you're going to be billing on a 1-month term. Every 30 days, you send in a bill. But what if the owner requires you to bill on the 25th and you haven't completed that particular month, but they want you to bill for that whole month? What do? Basically, you extrapolate out what you think is going to be the expenditure for the next 5 days and include that in your application for payment. Sometimes that works, sometimes it doesn't, but that's what I tell clients to do when they're caught in that situation. Many times also there's a pencil copy requirement. We've seen that from a lot of the larger construction managers. So in that situation, follow the pencil copy process. Make sure that your pencil copy is approved and whatever you submit matches up with the modified pencil copy. If there's a dispute with regard to that pencil copy, that dispute has to follow the dispute resolution clause if it's something substantial. The other aspect of payment is the schedule of values. Your schedule of values is supposed to lay out all of your work for the project. Some require that to be extremely detailed. I've seen schedule of values where it's done by floor in a high rise, for example. I've seen others where it's been done by unit in a high rise. You need to make sure that your schedule of values is appropriate before you submit it for approval. And once it's approved, then it shouldn't be modified except by adding change orders to the end of it. A schedule of values is not a guarantee of those prices for those particular items that are broken out in the schedule of values. It is just a logical breakdown of the entire contract sum. If you believe that your owner is an unsophisticated owner, that needs to be made very clear to them. Owners tend to believe that what is in the schedule of values is what that item is going to cost them. So, for example, if you have a switchgear package that you say costs $500,000, and the owner says, you know what, I'm not going to have you purchase that switchgear package. I'm going to purchase it myself. Give me a deduct. And your schedule of values shows $600,000 for that switchgear. They're going to ask for a $600,000 deduct when it should only be $500,000. So again, be careful, explain it to unsophisticated owners who think it's a guaranteed maximum price, and protect yourself in the long run. Retainage. What is retainage for? It's to basically hold over your head to make sure you come back to the job and finish it. And it also is to protect the owner if there are any issues that come up later in the job and the contract had already been billed out significantly. Now, 10% is the standard retention that we see in most contracts. Some states have limited that retention to 5% on certain projects like New Jersey. So you need to look at the business terms of what that retention is. One thing that we always try to negotiate into our contracts is that if the project is of any significant length, that at 50% completion of the project, that the retention be reduced. So for example, we would add a clause that says at 50% completion, the retention will be reduced to 5%. But what does that mean? Does that mean that they're going to take the 10% and pay you half of that at 50% and then only hold 5% for the rest of the job? Most contracts don't work that way. Instead, what they do is they hold the 10% from the beginning of the job and then hold 5% on the remainder of the job, so that at the very end, they're holding 7.5%. We believe that it should be zero, either paid up on the first half down to the 5%, or that on all future applications, the payment retention should be at zero, so that at the end of the job, the owner is holding 5%. So what happens with retention at the end of the job? It's now substantial completion. Most contracts provide for the payment of retention upon reaching substantial completion, with the exception of some amount to cover the punch list that needs to be performed at substantial completion. So it will say something like 150% of the value of the punch list will be held until the punch list is complete. So at substantial completion, you would bill for that retention except for the 150%, and the owner or GC would have to pay you pursuant to the terms of the progress payments under the contract. Here's a sample of a retention clause that I just discussed. Oop, too far. All right, well, we're going to do wow, what just happened? 1 second, sorry. I'm having difficulty getting it to stay on the previous slide. All right, well, let's just do this one then. Can a subcontractor perform all its work on a time Can a subcontractor perform all its work on time and without defects, but not be entitled to any money because the owner failed to pay the general contractor? If you believe the answer to that is yes, text yes. If the answer is no, check B. Just so that people know, I have gotten an answer to the poll in the question box as well, where it says no from that particular person. So the vast majority says yes, and those people are correct because of the issue of pay if paid clauses. So let's talk about what the pay if paid clause is versus what is a pay when paid clause. Your subcontract agreement, which has normally been drafted by the contractor, is going to say the payment to the sub is contingent upon the GC being paid by the owner. The word contingent is extremely important, and we'll get to the importance of that word in a minute. Now, many states, including New Jersey and Pennsylvania, enforce pay if paid provisions. So if there's clear language unambiguously reflecting an intent by the parties to shift the risk of non-payment by the owner to the sub, that is going to be enforced by a court. If it's not clear and unambiguous, it's going to be considered to be a pay when paid clause, and we'll discuss that in a minute. I said earlier the importance of the words condition precedent. This language, for some unknown reason, has been latched onto courts as the key language to say that the pay if paid clause is unambiguous. So it's going to say something like payment from the owner to the contractor is a condition precedent to payment from the contractor to the subcontractor pursuant to this article. If you want to avoid a pay if paid clause, the first thing you do is you strike this whole sentence. Then you try to just strike the words condition precedent if the contractor is unwilling to change this. So the contingency is basically, if I don't get paid, you don't get paid. That's what the condition is. You should try to avoid this at all costs. But on the other hand, as those who enter into prime contracts know, the GC doesn't want to pay when it hasn't been paid. It does not want to come out of pocket. So they're trying to allocate the risk of non-payment from their customer to the subcontractor. And even worse, the payment bonds can be similarly conditioned. So if you receive a payment bond from a general contractor on a project, but your subcontract has pay if paid language, even addressing the surety bond, the surety has that defense and does not have to pay you if the owner has never paid the general contractor. How do we address this? We, as I said, first tried to cross out the condition precedent language, but if that is unavailable, we try to convert the pay if paid clause to a pay when paid clause after a reasonable period of time. A lot of contractors have agreed to that. Just so that, to give you guys an example, I had a hotel project in the state of Virginia where the owner in the middle of the project went out of business and left the general contractor with about $4 million worth of bills, which it could not recover from the owner. It successfully used a pay if pay clause to avoid paying 99% of the subcontractors. Our contractor, through our office, had negotiated, because they had some leverage at the beginning of the job, to remove the pay if pay clause. They were the only sub to get paid, even though the owner had not paid the general contractor for no reason that the general contractor could control. So these things are enforced, and it is a major issue. Now, a pay when paid clause is going to say something like what is on the screen in orange. It's going to say the contractor shall make payment to subcontractor within 7 days of contractor's receipt of payment. This is more acceptable to courts than a pay if paid clause. It doesn't have to be clear and unambiguous. If it just says, I'm going to pay you when I get paid, that's fine. The issue is, what if they don't get paid by the owner? So they have not received payment. When do those 7 days begin to run? The answer to that is it begins to run within a reasonable time. Now, what is a reasonable time? I wish I could give you an answer, but the reality is that courts are all over the place. It is a factual determination made by the court in the given circumstances. I've seen a reasonable time being as short as 30 days. I have seen a reasonable time being as long as 3 years. But at some point, there needs to be a payment made.
And John, if I could just jump in real quick, those courts that allow these extended times to be considered reasonable are in those circumstances when the general contractor is taking affirmative action to collect those funds from the owner. So in those cases, the courts have seen that the general contractor is aggressively seeking to pursue those funds and all remedies available to it, it may require the subcontractor to wait a little longer. If the general contractor is doing nothing, the reasonable time period would be shorter.
So what we try to do when we are negotiating a pay when paid clause is set out exactly what the definition of reasonable time is for that contract. Generally, we include some language that if the general contractor is pursuing the owner, as George just mentioned, that would extend the reasonable period of time. General contractors are more likely to accept that type of revision than a revision that simply says if the owner hasn't paid within 30 days, you have to pay us. So you need to negotiate those. The more leverage you have, the better off you will be when negotiating. Now, what happens if you don't get paid? Can you withhold performance? As George mentioned a number of times yesterday, he and I have been doing this for over 30 years, at least in my case. In George's, I think it's exactly 30. You should not abandon a project. We have never told a client, except for in extreme measures where continuing would basically bankrupt the company, to abandon a project. Instead, what you should do is follow all of the notice provisions in your contract with regard to non-payment or claims, and study your contract on what your suspension rights are. Under the AIA contract forms, for example, if you are not paid within 7 days of when you were supposed to get paid, you can send a notice. And if you are then not paid within the next 7 days, you could suspend your work. And once you get paid, return to the job and get paid your cost for demobilizing and remobilizing. Know what your rights are. Also, if you're in a prime contract situation, ask the owner for financial assurance. Make sure that they have the financial wherewithal to pay on this project. And if they don't give it, many contracts allow you at that point to terminate or suspend your work. And as I said, pulling off a project is the last resort. Let's talk about schedules and warranties before I turn this over to George. Coordination. The issue with coordination is every general contractor thinks the subs are going to coordinate, and every subcontractor thinks that the general is going to coordinate. And the answer to that is they're both right. The general contractor is supposed to perform what we call the macro coordination. In other words, they are to coordinate all of the subs over the entire project, where the subcontractors have a responsibility to coordinate their specific work. So if the general contractor says, plumber and electrical contractor, you both need to be in this room on this day, when they get to that room, the electrical contractor and the plumbing contractor have to work together to perform the work in the most efficient manner. That's their coordination responsibilities, but it's the general contractor's responsibility to coordinate the entire job. With regard to the schedule, many contracts ask the subs to provide schedule input at the beginning of the job. This has to be done in a timely manner, or you're going to be given timeframes that don't work with your workload. Make sure that the schedule that you provide to them is accurate, that it provides enough float to allow you to perform your work, and includes your standard weather delays that you may face on any particular job. If you are required to create the schedule for the job, and this happens a lot with mechanical contractors who have to coordinate all of the MEP trades, make sure that the schedule is signed off by everyone at the start of the job so that there's no dispute over which schedule governs the project. Many times on bid schedules, you'll see that the bid schedule is no longer relevant once the notice to proceed is issued. It's important that you ask for a change order at that time. Simply asking for an extension of time of the bid schedule. If there are milestone dates in the bid schedule that are not going to be hit, make sure that you ask for a change order to extend those milestone dates out. One other thing with regard to schedule, electronic schedules are those items which should be asked for. It's one of those items that should be asked for at the very beginning of the job. An electronic schedule update allows you, if need be, to see how the general contractor has revised the schedule. And many times they cut logic ties to kind of push the schedule into the time period that the owner is demanding. If that occurs, you'll lose time on the job, you'll lose float, etc., that you thought that you had. Make sure that you ask at the beginning of the job when everybody is in their partnership mode, that you say that you want electronic schedule updates. Warranty. Here's your sample warranty provision from a contract form. You'll see that a subcontract normally says that it's 1 year for a warranty or such longer period as required by the specifications. So it's necessary, again, for you to see what the prime contract requires. And when does that 1 year commence? As I said earlier, it usually commences at substantial completion, but we are seeing more and more that it is starting to commence upon the owner's final acceptance of the entire project. So if you have a situation where you've done your work and there's about 6 months more of landscaping or whatever on the project, your warranty is not going to run until the entire project, including that landscaping, has been accepted in writing by the owner and the architect. You need to try to revise that language to make it clear that the 1 year is going to run from the end of your work or from the substantial completion of your work or the substantial completion of the whole project. Final acceptance really opens you up to a longer warranty period. So how long does a warranty run? Again, usually it's 1 year. That changes. But one of the things that everyone here should know is that the 1 year time period is not how long you are actually obligated to fix the work that you did. All the 1 year is your obligation to go back to the job and fix it. If something happens in year 2 and it's determined that your work was done improperly during the course of the project and is not discovered until year 2, the owner can contact you, or the GC can contact you and demand that you return to the site to fix it. Do you have to go back to the site? No, but they then can hire someone to correct your work and then sue you for the cost to do so. The statute of limitations is really what your warranty period is. It's just that you don't have to go back and fix it. The other aspect of this that gets lost a lot is the statute of repose. A statute of repose is how long an owner has to discover defective work. So the statute of limitations does not begin to run until the owner has actually discovered the error. That is what is called the discovery rule. So the statute of repose gives the owner a certain number of years to determine, or excuse me, to discover the problem. The best example I have is that I was representing an owner on a Home Depot project. The Home Depot was built 7 years ago. A tornado came, knocked down some of the walls in the garden center of the Home Depot, and it was determined that the masonry contractor had not installed any rebar in those bricks 7 years, 8 years earlier. We were able at that time to say we could not have discovered that issue until the wall actually fell. And given that the statute of repose was 10 years, we were still able to file suit against that masonry contractor for the rebuild of that garden center. And with that, I'm going to turn it over to Mr. Pallas.
Thank you, John. And hopefully my technology will allow me to move the slides. And I am mindful we'll take a break at 10 o'clock, as we discussed at the beginning of the webinar, for 5 minutes. All of the contract provisions that John just went through and that we went through yesterday illustrate that there are many pitfalls in the nature of construction all along the way, really from tip to tip. And so therefore, we're going to now start talking about claims and notice, which is critically important in your defense of any of these pitfalls and how to navigate around them. So let me see if I can turn that slide. There you go. So the AIA defines a claim as a demand or assertion by one of the parties that they are entitled to money or time. So let's not kid ourselves. On every single project you're on, you have claims. There's always a scenario in which something didn't go exactly right. There was either some sort of confusion or uncertainty with respect to the design documents that required additional work. There may be some problem with the coordination of the various trades that required an extension of the time of the project schedule. There could be interferences with respect to any aspect of your work, and as a result, you had to spend an extra man day performing work, or you were on the site an extra day than you anticipated. Every project has claims. The issue then is, what do you do about it? What do you do about it? So once a claim arises, and they arise on every project, that automatically triggers your notice requirements in your contract. And those notice requirements will set forth what you have to do by writing in order to secure and reserve that claim. And those claims, John, I lost the whole screen. Do you have it? There, up the next slide, thanks. You have the next slide, John? 1.2. There you go. So those notice requirements apply to money and time, right? Any claims that you have. And those notice requirements that are in every one of your contracts have to be understood by your project managers, because if you don't understand the notice requirements, then you will run afoul of that contract requirement and you could jeopardize your ability to prosecute your claim. So what the best practices here is to avoid notice provisions that are short in time period. Those notice provisions often say that you have to provide written notice to the general contractor within 7, 14, 21 days of the occurrence giving rise to the claim. That is, those time periods are probably reasonable, but many CMs are now putting in timeframes that are much shorter, and we're seeing timeframes of 24 hours, 72 hours, and that is what is more problematic. So you're going to, in the contract negotiations, you want to do your best to negotiate them a little more reasonably. In addition, many contracts will include notice provisions that require you to set forth the entire scope and nature of your damages, as well as to, if you're looking for a time extension, to include with your notice a time impact analysis to illustrate the impacts to the schedule. That could be onerous because at the time of the occurrence of the claim, again, on every job, you may not have a complete grasp of the nature and scope of your damages, nor the impact to the schedule. So you still must provide notice, and if you don't do that, you may run the risk of losing it, your claim, but your notice should indicate if you're unable to identify the scope, magnitude of your damages or time impact, you should say so. Make that very clear, and then you will update the notice when you have that information. I also cautioned you yesterday about mandatory provisions in these contracts that require strict compliance with the notice requirements. And that includes where the notice needs to be sent, the form in which it must be sent, and what information must be included in the form in order to satisfy the notice requirements. You also need to be very mindful of what the prime contract requires, because as John indicated, often, if not always, the prime contract is incorporated by reference into your subcontract, and you would be bound by those notice requirements as well. So these notice requirements are critical, and if you fail to honor them, you run the risk of forfeiture of the claim. In fact, many contract requirements will state specifically, if notice is not provided, then the claim can be forfeited. That then requires your legal team to argue equitable arguments to go around that forfeiture. And those equitable arguments do exist, a course of dealing, prior business practices, unfairness. There are actual notice. There are equitable defenses around that. But like I said yesterday, it can be very expensive, all of which will be avoided if we simply provided the notice as required by the contract. So the next contract provision that I wanted to speak to you briefly about is the differing site condition clause. These clauses are in each of your contracts, and they essentially state that there are really two types of differing site conditions that you may want to be aware of. One is called type 1 versus type 2. A type 1 differing site condition is a condition in which you encounter in the field that is materially different than that reflected on the contract documents. So you're encountering something that is completely not reflected on the contract documents. A type 2 is a condition that you encounter that is not contrary to the contract documents, but is something that is inherently adverse or inherently unexpected, materially unexpected in the nature of the work that you're providing. The most classic examples of that is with the underground work, and that is you may look at the geotechnical information or the borings, understand that the project is sitting on sand and clay material at certain elevations for your underground work, and then when you try to install the underground work, you encounter a bedrock or blue granite. or some other unforeseen soil condition. That is the most classic example. In each type 1 or type 2, again, that's a claim that triggers your notice, and each time there has to be a notice provided to the general contractor and to the owner. Many times, owners will declare a site to be unclassified. When there's an unclassified site, they're essentially saying you own the risk of what you find under the subsurface conditions. You own those conditions. They're not classifying it. They're saying it's whatever's down there you own. And that's important to understand whether there's a designation in the contract documents of an unclassified site. You need to be aware of that when you're bidding the job. Every contract that you sign requires a familiarization of the site, and they state affirmatively that the contractor, the bidder, the subcontractor, has gone to the site, has investigated the site, and has fully familiarized itself with the conditions of the site. Why that's significant is because if the borings, for example, show that the area of the work that you're in is going to be sand and clay, for example, but you went to the site and you saw outcroppings of rock at various locations, they may argue that, well, had you gone to the site, you would have seen the rock everywhere, so it's not unexpected that you may encounter rock, even though at the precise location of the boring, rock wasn't detected. And that would be a condition. For example, another one on an interior work would be if you had to do in a renovation project and you had to run some overhead work, above in a plenum above a ceiling, in a drop ceiling, there may be a second ceiling above that, right? So that's not otherwise disclosed. Had you gone to the site and done a reasonable inspection, you might have popped open a drop ceiling and observed that the plenum was not what was reflected on the drawing, and was in fact there was a second obstruction there, and that's something that is important to be aware of, because the law is going to assume that if you could have discovered it during a site inspection, you own it. The geotechnical reports, can you rely on them? A lot of contracts will lay out there a provision that says they're as is, that you cannot rely on them. But there's a body of law in the federal construction world that if there is a differing site condition clause that allows recovery under type 1 or type 2, the government cannot hide behind any kind of exculpatory language in the contract, which says that you can't rely on the geotechnical report. Unfortunately, in New Jersey, that law is unsettled. So what often happens is owners and general contractors will rely on language in the contract that says that the information that's provided for geotechnical and any other investigative reports provided in the contract documents are for information purposes only, and that you cannot rely on them, even though we know practically in the real world we're all doing that. The law on that enforceability of that exculpatory language is unsettled in New Jersey. New Jersey is in the minority of states around the country on this issue. So why don't we take a 5-minute break, and when we return, we will start talking about time extensions for delay. It is now 10:03. We'll return back at 10:08. Thank you. Well, we're back. I hope everyone enjoyed their brief break, and let's continue if we can. So with respect to the notion of claims and notices, right, we recommend to our clients that not only do you understand what the requirements are in the contract with respect to time extensions and claims for time extensions or delays, but we recommend as a best practice that every contractor should every month ask themselves certain questions with respect to where the project stands in order to get a better understanding of whether there's an impact to the job that requires a notice to be provided. So you should be asking yourselves on a monthly basis with your project management and your project accountant exactly where you stand. Are we on time? If not, why not? Right? And if it's somebody else's fault that you're a little behind schedule, that means a claim has arisen and notice has to be provided. If you're late because something that you did, well, then you need to rectify that scenario immediately. You don't have a claim. You have to rectify that situation immediately. So you simply just can't assume that things are going to be working out for the best because that notice, the event giving rise to the notice of due to a time extension would have occurred in that month. And if a notice is not provided, you would have been deemed to have waived it. So to assist our clients in trying to monitoring that, as you may recall from yesterday's presentation, we provided a checklist to do contract negotiation or pre-bid. Well, here is a project manager's checklist that we provided to give you a sample that you should be asking along every month and having this in your project files. You know, these can have a series of questions. You know, are we receiving monthly schedule updates? You know, are we ahead or behind schedule? Are materials are ordered in a timely fashion? Are we having problems with manpower? You know, are we experiencing stacking of trades? Are we being accelerated? And there's a series of questions with the yes or no. And if you answer in the affirmative on these questions that yes, there is a problem or we are being impacted from other sources, well, that will automatically trigger your notice requirement and then require you to submit a writing consistent with the notice provisions to the general contractor in order to avoid the pitfall of a delay or other impact. Most contracts that you sign have a force majeure contract provision. This provision here comes from the AIA, which essentially says that there is a delay to the project due to circumstances beyond the control of the owner, that you may be entitled to a time extension, but maybe not money. This becomes particularly important under some of the language that we have with force majeure as it relates to our current circumstances with COVID. We believe that the COVID situation is a circumstance which is that the contractor is unable to overcome, even through the exercise of due care and proper precautions. However, now that we are 3 months into this, 4 months into this nationwide shutdown and pandemic, a lot of information has come out with respect to how we can best protect ourselves, protect our employees, and that nature. So taking staggering of workforces, safety precautions at job sites, all of these conditions now may be argued to be in your control, and therefore the blanket I'm going to hide behind a COVID impact to a job delay may not be sufficient under force majeure to protect you and get you the time extension that you'll need, because it may be your fault. Weather is another issue that may arise that may cause delays to a project. Now, in every project schedule, there is inherent that if you have outdoor work, especially, that there is going to be days that are bad weather, rain, wind, snow, temperature. There's factored into the schedule. It's assumed when you bid the job, you're factoring in, normal working weather conditions. However, if the weather is abnormal, which it means that these weather conditions exceed what the National Weather Bureau has for that in that area for that month, then you may be able to argue that you are entitled to a time extension, but not necessarily for money, for a time extension because you're encountering what they call abnormal weather. And in order to prove abnormal weather, it really is a combination of comparing what the National Weather Service data provides from the area closest to your project to what you're encountering on the job itself. We have successfully sought time extensions for wind chill factors, for example, when we were doing outside work and the tenting and temporary heating can't suffice for the work. But be mindful, just because you have bad weather doesn't mean that you automatically have a time extension. With that said, however, I want to show you a couple of photographs, if I can, and to illustrate another point. Let's see if I can get the slide over. So in this event, you'll see let's say there's a 8 to 10 inches or 12 inches of snow. So on that snow event may be considered abnormal and may not be, but having a site covered with a foot of snow has a lingering impact on the project, and that lingering impact may be grounds to seek a time extension for adverse weather. On the same token, if you have a bad rain event, for example, the day it rains, we have a rainy day, but it may turn the site into something of a big mud pool that are out there that may last for days, and depending on the soil condition, in order to get that out of to a condition that you can manipulate and move around the site very easily. In addition to weather, of course, there are always other obstructions that may impact you on the job. For example, contractors laying looks like conduit or other lines all over the place that would not prevent you from access to the work area that you need. That would be another example of something that may impact or delay your work. So how do you notify the owner or the GC of these delays? Well, you know that answer. It's in writing, right? Always in writing. If it's verbal, it's as if it didn't occur. Should your notice identify areas of work impacted by delay? Of course it should. You should be specific in your notice. We are being delayed in wing B for these following reasons. Should you identify in your notice the manner in which you're being damaged? Of course. We are being damaged because our men are standing there idle, and we have equipment that is running idle. How do you quantify the days of delay? Well, you do that the best you can. And one way to do that is say, while that condition exists, for each day the condition exists, we are being delayed for each day. And the notice should say, once we fully understand the scope of that delay and the impact of the schedule, we will let you know. Now, some of you may be saying, if I write these notices every time there's a delay or every time there's a claim that I think I'm owed time or money, I may be perceived by my client as claim happy, that I am an aggressive contractor that files claims all the time. But we don't see that in our experience, John and I. We just simply don't do that. If you act professionally and in a sophisticated manner and in compliance with your contract, that's all that you could be asked to do and expected to do. So if you look at the next slide, we have a sample letter, which essentially says, look, our contract requires to put you on notice of a delay or other impact to the project. And we say, while we do not have a desire to become adversarial, we do recognize the need to adhere to our contract requirements. So I'm going to let you know, here's the result. I'm going to let you know how I'm being impacted. I'm going to lay it out for you, and I will provide you with the cost impacts at a later date once I get them. Now, this letter is not adversarial. It protects your rights under the contract. It serves notice, and it protects your rights. Why are we doing that? Why are we giving notice of these impacts to the general contractor? The theory is because you want the general contractor to fix the condition. You're working collaboratively with them so that you can solve the problem in the field, have the other trade get out of the way, move the obstruction as best that you can so that we can work together. If you do not provide the notice, then the general contractor says later during the divorce proceedings, I didn't know you were impacted. I didn't know that weather impacted you. I didn't realize it was costing you money. Had you told me 18 months ago, I could have made these changes. So now during the divorce, you can't hold me liable. And that's why it's important to have those notices provided. So we have a poll question, says where time is of the essence, if the owner or the general contractor delays your work, so they're the ones that are delaying it, can a contract that was signed before anyone contemplated the specific cause or duration of delay limit your damages to the receipt of time, but not money? Let's take a moment and look at that. Okay, so most of you have believed that the answer is yes. And the reason why you're saying that is because you're familiar with a no damage for delay clause um, in the contract. These clauses make very clear that if you are delayed for any reason, the subcontractor, not due to the subcontractor's fault, you may be entitled to a time extension, but you're not entitled to money. But we know that when a job is delayed, there is an impact of money to the contractor, right, being affected by the delay. So are these provisions enforceable? They are. These are enforceable provisions. But the law in many states do recognize certain exceptions to the enforceability of a no damage for delay clause, right? It depends on the jurisdiction. For example, in New Jersey and Pennsylvania, they recognize the exceptions that if the delay is caused by the active interference of the owner or the general contractor, that they cause the delay, that the subcontractor would be entitled to a time extension and money. But in New York, Massachusetts, Connecticut, and other states, the no damage for delay clause is much more strongly interpreted. And if the contractor is delayed, they get no recovery whatsoever, regardless of whether you refer to it as a delay or disruption or inefficiency. So in those states, it's a little bit more difficult. In New Jersey, we have a means to circumvent the enforceability of the no damage for delay clause if we can demonstrate that it was due to the active interference of the GC or the owner, some type of delay not contemplated by the parties, some wrongful conduct, or an unreasonable delay. The next provision I wanted to speak to you about is a liquidated damages provision. These provisions are often contained in your contract. And the concept behind them is that the owner really it's uncertain how to calculate damages in the event that project is delayed. But they know they're going to be damaged, but they're not quite sure how or what the amount is. So the theory is let the parties negotiate a number right now so we can avoid that. And if you cause the delay of a project, then you should be assessed a damage per day for each of those days of delay that you caused. Now, liquidated damages are enforceable. They are enforceable around the country, and they often flow down to the subcontractor. So what does that mean? If the subcontractor caused the delay of the project to the critical path, pushing the end date back, then they may be susceptible to an assessment of liquidated damages. If the job is delayed, but it's not caused by you, then they cannot assess liquidated damages against you. You have to be the cause of the delay, and that requires a time impact analysis of the project schedule to determine what conduct you may have done that impacted the critical path. Now, are all liquidated damage provisions enforceable across the board? No, there are defenses to them. So what are the defenses? The defenses are the liquidated damage amount cannot be deemed as a penalty. If it's deemed as a penalty, the law looks at that as a forfeiture, and it will then look at that as unenforceable if it's a penalty. So how do you determine whether it's a penalty? The law also imposes an obligation upon the owner pre-contract to do a reasonable investigation and to determine a reasonable assessment to calculate what their anticipated damages would be. How often does the general owner do that? Not often. What typically happens is the architect will just take a liquidated damage provision that they've had for other projects and apply it to the new project. The law says if the owner does not perform that pre-bid, pre-contract investigation and analysis to determine what their damages would be and to properly forecast their damages, then the liquidated damage is considered a penalty and will not be enforceable. So that's important to realize that even if you're getting jammed down your throat a liquidated damage, there are defenses that you can assert to their enforceability. So let me talk to you a little bit about the default provisions.
Hey, George,
yep.
Can I just make a
Sure.
comment on liquidated damages? Liquidated damages are not always bad. If a liquidated damage for a smaller amount of money than what the owner would actually incur, you could all see that it benefits you to agree to the liquidated damage. So if it's $500 a day on a multi-million-dollar project, it may be beneficial to accept the liquidated damages. Also, if you challenge the damages, liquidated damages, as George just said, it's not like you walk away scot-free. The liquidated damages then get replaced by the actual damages that the owner incurred. They just have to prove them. That's it, George.
That's exactly right, John. And in litigation, it has to be pled. So last month, I had a project, a prime contractor against the city of Philadelphia, in which the liquidated damages being assessed were $2.7 million. And we did discovery and discovered that the city of Philadelphia literally took that damage provision off of another project and did no forecasting pre-bid. And as a consequence, the court dismissed the liquidated damage claim in its entirety, and will allow the city to focus on their actual damages. The problem with that is, and in many times, the actual damages also, they have requirements to let us know what they are and to be able to prove them that all of those damages were reasonable and as a result of the actions of the contractor. So while they may default to actual damages, dismissing the liquidated damages is a big plus, because it forces the owner to have to now prove with reasonable certainty what those actual damages were incurred and assess them against us. So let me move on to the default and termination provisions briefly, if I may. And let me see if I can get this smooth. Okay. Most of your contracts that you're signing have a default provision, right? Which essentially says that the owner has the right to carry out the work if you fail to do so, and they provide you with a written notice to cure, a written notice of default. And if you fail to do that, then they have grounds to terminate the contract and do that. So there are two types of termination. One's for cause and one's for convenience. And so what is a termination for cause? A termination for cause is a circumstance in which the subcontractor or the prime contractor in either case fails to perform materially the obligations under the contract, either by abandoning it, not providing sufficient manpower, creating excessive delays. And after the owner provides notice to the contractor to cure or remedy that condition, if they fail to do so, then the contract would provide a mechanism to terminate the contract for a cause. And what that means then is if there's a legitimate termination for cause, the owner then can complete the project with other resources and then apply the unpaid contract balances to the replacement contractor, and if there's a shortfall, hold the defaulting contractor liable for that shortfall. Does the owner have to give you a reason? They do. This is not a secret thing. The default has to be material. And what does material mean? Well, material is defined by various cases and by the restatement of contracts, that it has to be something that is severe, that goes to the actual heart of the contract. So, for example, if you have to provide sufficient manpower in order to maintain the progress schedule, that'd be one example. That may be considered material if you've persistently failed to do that. But what if the contract required you to sign the change orders in blue ink, but you signed it in red ink? Well, technically you're in breach of contract because it said blue, but because you used red. But that wouldn't be a basis to terminate a contract, because the default, while it's accurate, is not material, and therefore it wouldn't be a grounds to do so. Does the contractor have to give you an opportunity to cure? If it's in the contract, the answer is absolutely yes. If it doesn't provide a notice to cure in the contract, then you're forced to look at what the common law is and what the state case law is in New Jersey with respect to an opportunity to cure. And there is a lot of case law out there that suggests that if you're going to forfeit one's rights, you have to give them an opportunity to remedy that scenario before you can actually terminate. So, and I will tell you that courts generally and the law generally do not appreciate the cessation or forfeiture of rights without the opportunity to be notified of a problem, and the opportunity to try to correct it. And that's something that is it's just generally important in the law generally. So does the owner have to give notice? Well, obviously, if it's in the contract, it has to. And if it's not there, it is something that the common law will look for the owner to do so, and that would be bad if they did not do that. But for purposes of contract negotiation, you absolutely want that notice requirement in there. Sometimes it has a double notice. You have to cure within 7 days, and if it doesn't cure within 7 days, you have to give another 7-day notice to terminate. That's a great negotiating at the honeymoon stage of the relationship to give you ample opportunity to get notified of a problem. And that includes with respect to any back charge, right? You would want the owner or the general contractor to notify you that you have an obligation to clean up the site, and they can back charge you if you don't. But it's better if you have a notice to say that you're not cleaning up the site, and you have 72 hours to do so, otherwise you'll be back charged. It's the same concept to do that, and it should be negotiated up front. A termination for convenience is, well, the owner really doesn't, the general contractor doesn't have a reason. They're getting rid of you for really no reason. It differs from a termination for cause is because you do not have to be in material breach of the contract to be terminated. They are enforceable, right? They are enforceable. And once they are enforced, it's the express language in the contract that will dictate what exactly you get under that circumstance. Many times, you simply get the value of the work installed up to the date of termination. That's it. You do not get overhead and profit on the work not performed. But again, that's the function of your contract negotiation, and most owners will strike that right to the profit on work not performed completely. So a way to try to help negotiate that, and we have here some examples of a termination for convenience clause, and where its standard says, a subcontractor will hereby waives and forfeits all claims for payment and damage, including anticipated profits. So they kind of get you out of that completely. So one way to try to mitigate that is to negotiate a sliding scale provision, which essentially says, look, if I'm 25% complete and you terminate me for convenience, which is your option, pay me a termination bonus of X. Or if I'm 50%, make it Y. It's something like that. And this gives you an opportunity to say, look, we recognize the right to terminate for convenience, but if you do, it's going to cost you a little bit of money to get out. And that's something that we've had success in negotiating. What is becoming much more prevalent now, and it's just really something that is really even more another pitfall, is that sometimes when a contractor terminates a subcontractor, again, it has to be based on a material default, they do so improperly. They either do so improperly procedurally because they didn't give the notice and the opportunity to cure and just said, get off my job, or substantively, it's improper in that the subcontractor was in fact not in material default of the contract and is then deemed by a judge or a jury that the termination was wrongful. So you think, well, that's great. It's great for the subcontractor. You win your case. But many contracts now are including provisions in their contracts that say, if the termination is deemed wrongful, the termination will then be converted to a termination for convenience. And the reason why that's so significant is that if that provision's in your contract, that it converts. Well, let me back that up. If you are terminated and it's deemed to be wrongful, well, then the defaulting subcontractor who wins their case is entitled to the overhead and profit on the work they did not do. And that could be a big number, right? If it's for convenience, you're not entitled typically to that work. So general contractors and owners are including this provision in their contracts that say, look, if I terminate you and it's deemed wrongful, like I made a mistake, oops, it converts to convenience and you still don't get any money. And that is a problematic provision in the contract that needs to be in your negotiating, be aware of it and try to remove it because it does not provide an incentive to the general contractor or owner to be more cautious in their termination. So it is a problem that we see often, and that is something that we think that needs to be addressed. Is it enforceable? Is this conversion enforceable? There's case law in the federal circuit that it is. There's nothing in New Jersey on the issue, And I have this exact issue right now that that's going to be pending before the New Jersey federal court. This is exactly what the issue is. There's something inherently wrong with it, this conversion. I think it smacks in the face of fair dealing, good faith and fair dealing in contracts. And I think that is a problem. But we'll see what the court says about it. Can you be terminated for convenience for any reason whatsoever, right? In most jurisdictions, the answer is yes. And the reason why many general contractors will terminate convenience is maybe they get a better price. And they realize, look, if I can terminate you after you finish quarter A because I got a better price for quarters B and C for somebody else. So they kick you off and bring somebody else in. There's a Maryland case that we cited that said that's not enough. You need to have some legitimate business reason for doing so, and just can't have it for any or no reason whatsoever, because there is a duty of good faith and fair dealing in all contracts, but New Jersey does not have that contract provision in it, law in it. So let me speak to you briefly about dispute provisions. We all know that dispute provisions lays out in the contract, what happens. If you have a fight, where do you go with it? You can litigate it, jury or non-jury. You can arbitrate it, which is binding through AAA or some other forum, or there's mediation as a process. So you should be aware of what this is. We are, John and I are major proponents of mediation as being a condition precedent to proceeding in any type of forum. We think it's an opportunity to get into a room and try to get this thing taken care of, any problem taken care of. We view these items of litigation, arbitration, mediation, really we call it the big show. It's where you get to show and illustrate to the trier of fact why you're right and why the other side is wrong, and why you're entitled to it, to the relief you're seeking. That's why all these notices and these time and material tickets and photographs and all this documentation that we're going to talk about in a few moments is so critically important, because if you go to the big show, litigation, arbitration, or mediation, without a big pile of stuff, you just simply are prejudicing yourself and not be able to convince anyone in earnest that you're entitled to the relief you're seeking. You should also be aware of choice of form clauses in your contracts. And a lot of these, especially the out-of-state contractors that come into our state, they often will ask you to agree to a provision that if you're going to fight litigation, arbitration, or mediate, it's going to be in the home state where they're located and not where the project was located. And there is a lot of statutory provisions and by many states that hold those provisions unenforceable. If you're going to seek relief under the Prompt Pay Acts in their various states. So here's an example of a dispute resolution provision in a contract. Many times you have to submit the dispute to the architect as the initial decision maker, and once that decision is done, then you can select arbitration, litigation, or some other form to get rid of it. I spoke briefly about mediation. We know it's non-binding. It's just a shuttle diplomacy in which you try to make your case and try to convince an independent third party why you're right, and have that independent third party, the mediator, shuttle back and forth to try to broker a deal. Mediation is a contractual precedent. Making it a contractual precedent is a very good process. We believe firmly that if you can present well to a third party, show the other side all of the evidence that you have, you can avoid litigation, and reasonable minds will come to bear and get rid of the problem. The initial decision maker through the AIA is the architect, and as a process get through that. I don't find that particularly successful in our processes to do that, because they're too ingrained in the job already. But I much prefer an independent third party to do it. Arbitration, of course, you know what that is. There's different forms that do that. You actually hire arbitrators, 1 to 3. They're either engineers, they're architects, they're lawyers, they're former judges, and they hear your case. It's in a conference room. People are sworn in. There's cross-examination. There's direct examination. There's exhibits. There may be a court reporter there. The rules of civil procedure do not apply strictly, but the rules by the governing body who is hosting the arbitration those rules do apply. There is, if you're going to have a contract provision that requires arbitration, be wary of the pick one arbitration, and that's a scenario in which each side picks an arbitrator, and then the two arbitrators select a third. It's cumbersome. It doesn't make any sense to do that. Some contracts included. We're not a big fan of it. It seems to be the best way to do that is simply to agree in your contract, if you're going to go with arbitration, to have what that looks like in terms of discovery, in terms of the number of panelists, and who the qualifications are of the arbitrator. All can be negotiated up front in your contract. There is a choice provision here, and what we recommend to our upper tier contractors, they should maintain the right to select arbitration or arbitration or litigation, and that should be reserved to the upper tier. And the reason why that's the case is because arbitration or litigation can be used strategically in problem solving, right? If you have a technical dispute with a lower tier contractor, it's technical, you may not want to judge a jury of bakers and secretaries and nurses deciding that. You may not even want to judge who's handling criminal cases and security fraud cases and doesn't really have the time or bandwidth to understand the technical issue. In that case, you may want to submit the dispute to a technician. On the same token, you may have a problem, you may be in a much stronger financial position than your lower tier, and you may want to drag out the dispute resolution and litigation, thinking that that could be a strategic weapon and force the lower tier to reach a compromise with you as soon as they can, rather than face litigation that can be extended. There is also a governing law provision in your contracts that are typically included in the contract. Disputes that are resolved in states other than where the project is located is what we talked about earlier, which it could be problematic. So it puts you at a disadvantage. For example, we talked about New York and Massachusetts with no damage for delay. So you want to make sure that the governing law provision in your contract is the law that applies in the state in which the project is located. There is also a waiver of consequential damage provision typically in these contracts. What is a consequential damage? Well, it's an indirect damage. It's not it's like you lost rent, lost profits, lost use of your finances, lost rental income. Things of that nature are considered indirect damages as a result of a breach. But there's always problems with those because there's an old case that John and I know from law school back in, what the year it was. But the damages must be foreseeable to be recoverable, and there's a lot of implications in there if you have these unforeseen or undiagnosed or unidentified damages. So many contracts will have a waiver, typically a mutual waiver, where both parties are agreeing to waive these type of damages in any dispute. Typically, that's very beneficial to the subcontractor, not so beneficial to an owner, right? Because the owner has all kinds of damages associated with an impact. So it's something that you definitely want to keep an eye on. John and I referenced this Perini case in the material, just to point out that there was not a waiver of consequential damages in this particular contract for Perini. They were building the facade of a hotel in Atlantic City. As a result, the job came in late. The hotel couldn't open, and they argued that as a consequence of Perini's default, they lost millions upon millions of dollars in lost revenue and profits from gambling activities. This is going back into the 70s, and Perini was hit with a substantial multi-$10 million verdict as a result of that, having that waiver contained in the contract. So, John, let me pass it over to you. I know you want to talk about indemnification issues.
All right, George. We're kind of running out of time, but I'm going to quickly go through this. One aspect of every contract to indemnification. What type of liability do you have in the event that someone is injured on a particular job? The construction contracts all have different indemnity forms. Some are broad form, some are intermediate, and some are limited. And we will go through those basic types of clauses. The types of indemnity permitted vary state by state. Many states have anti-indemnity statutes. Delaware, for example, has one. They bar a broad form indemnity and sometimes even intermediate. So let's go to here. Here's a broad form indemnification provision. How you can determine that it's broad form, where you're going to have to defend and indemnify the general contractor, even if the general contractor caused the entire problem, is if somewhere in that clause, you see the orange language at the bottom of the screen, it's going to say, and if caused in whole or in part by an indemnified party. So in this situation, you're an electrical contractor, you're on the job, you've done everything right, and the owner or the general contractor directs someone to stick their wet finger into a socket, and they get electrocuted. Even though the general contractor caused the entire problem, the situation is going to require you to defend and indemnify them completely because of this broad form indemnity. And because of that, you can see why many states don't allow them. An intermediate form takes away that whole concept, and instead, as the orange language says down at the bottom, directs to indemnity if it's caused in part by the indemnified party. So in this situation, if you are 5% responsible for an injury and the GC is 95% responsible, you would still be required to defend and indemnify them because it was caused in part by them and in part by you. One important aspect of indemnity ties into your workers' compensation insurance. Generally, an employee injured on the job, their sole remedy against their employer is through the state's workers' compensation system. And the employee can't sue the employer in tort, basically file a personal injury suit against the employer. But what occurred was they would sue the general contractor in the case of an employee of a subcontractor. They would sue the general contractor, claiming they had safety obligations on the project, and the general contractor would then try to join the subcontractor into that lawsuit, basically circumventing workers' comp. Under the law, that was not permitted. But now someone has wised up and they've drafted a clause that waives that workers' compensation immunity. So not that the employee can sue you, they are still limited direct to the workers' comp coverage. But if they go and sue the owner or the general contractor, you can be joined into that lawsuit through the indemnification provisions that we were just talking about and be forced to defend and indemnify the owner and the GC. And whether that is permitted goes state by state, but it is permitted in New Jersey. And this is your typical waiver of workers' comp immunity. As you see in orange, hereby your sub hereby expressly and without reservation waives any defense or immunity it may have under any applicable workers' comp laws or other statute. This has now become the commonplace provision, and you should be discussing this with your insurance broker to make sure that your insurance covers you in the event that this end run around workers' comp requires you to indemnify the owner or general contractor. With regard to insurance, it's important that everything be laid out. One of the things that as a subcontractor and as a subcontractor should be aware of is many times the insurance requirements of the prime contract are simply flowed down to a sub. This becomes a huge issue when the sub is doing, $20,000 worth of work, and the prime contract requires them to get $4 million worth of CGL policy coverage. It's important at the beginning of the job that be discussed and that the types of insurance be realistically tailored to the particular job. Let's see. Always have your insurance requirements reviewed by your broker. Don't rely on your lawyer to review that alone. Every time I'm asked to do that, I say to them, go talk to your expert who is the broker, not the lawyer. Also, if you perform any electrical design, any engineering, make sure that you have adequate errors and omissions coverage. You'd be amazed at how many people do not cover themselves appropriately on errors and omissions. We already talked about have we talked about waivers? Let's go on. So the types of claims that you have, we're kind of running out of time, but the claim process is always laid out in your contract. It's a rare contract that doesn't include how you take a claim through the process, and understand that those claims include for money, for time, or for both. The key is to substantiate your claims, as George was talking about. The documents are your Bible. At every job meeting, make sure that you discuss the issues that are a problem, and make sure that those meeting minutes reflect that you raised those issues. If the meeting minutes don't reflect what you said, you must respond to those meeting minutes, usually within 3 days, explaining why it's being ignored or not included in the meeting minutes. Whenever you submit a claim, the general contractors have all been trained to say no. Never allow that to be the final answer. Always push back, say that there's an obligation under the contract, that it was properly drafted by notice, that there has been no release, etc. Do not let the general contractors and the CM simply push you through. These are the types of delay claims. Non-excusable delay is a delay caused by you. You get no compensation for that. An excusable but non-compensatable delay is one where no one is at fault, usually the force majeure type language that George was talking about. And the final one is the excusable and compensable delay, which means that the party above you has caused the delay. And if you can prove the amount of time and the amount of money lost, that you will be able to recover. Let's see, I'm going to take you through. Here's a notice that we have prepared that's in your slide deck relating to delay and how you do it in sort of a kind fashion. Again, you're required under your subcontract to put them on notice, even if it's a short delay. And remember, short delays all add up. You have to adhere to the provisions, and here's the reasons why we're being delayed on the project. So always put the general contractor or the owner on notice per the terms of your contract. And look, realistically, you're not going to be doing that for every delay, but as more and more delays lump together, you're going to have a bigger impact. And the worst thing that could possibly happen is at the end of the day, you have a tremendous work hour overrun and have not put on it notice to anyone. As George discussed, I can't remember if it was yesterday or today, it's very important that your project managers work together with your accounting department and track what hours are being spent, how much is being lost on the job, etc., so that the proper notices can be filed and the release is not signed. So here's a couple of versions of various notices. There's also acceleration claims. An acceleration claim is more in the lines of you were entitled to an extension of time, but they have decided not to give you one, and they hold you to the original completion date. In that circumstance, you are not being delayed anymore, you're being accelerated. And it's important that you place them on notice. They'll immediately come back and say, well, you have a no damage for delay clause, there's a force majeure situation, etc. If you remember the clause that we discussed earlier, you are entitled to an extension of time. If they don't give you that, you're being accelerated and should be submitting a claim. All right. Listen, because we're running out of time, I'm going to basically close out at this point. Unfortunately, we've hit the roadblock of almost 11 o'clock. Understand that the slide deck goes on to talk about delay and acceleration, as well as the types of project documents you should be keeping. George and I are always available for questions. Please feel free to contact us. Our information is contained in the last slide of the presentation. And you can email us or call us. With these questions, there won't be a charge for the simple telephone call. And we thank you for your time. George, do you want to say anything else?
Sure. Obviously, if there's any questions, we can certainly respond to you to any of the questions you may have. But listen, John and I have been doing this for 30 plus years each, and this is all that we do. And we recognize in so many occasions on either we're defeating a claim or we're defending a claim, all of which could have been avoided and results been much more equitable had the contractor done what they were supposed to do under the contract. So these notices that we're talking about and being familiar with the contract provisions, having your project manager know them, could save thousands and thousands of dollars just in litigation costs. And John and I are often saying that if, because we lecture around the country on these topics all year long, that if everyone who's listening to our voice followed what we said, we'd be out of a job. And we lecture to do that. So just be mindful. Make sure your project managers read the contracts and understand these terms that we're talking about, because there are numerous pitfalls, but the power is in our hands, and its power is in the subcontractor's hands, that you can get around all of these pitfalls and protect yourself from everything that we're talking about if you're simply aware of what the requirements are and are not afraid to use your fingers to type out emails and to document the dollars and costs that are being incurred, and the occurrences, and notifying people of the occurrences, and always being professional. You be in a great stead from that. So again, we're here for you, at your disposal. Anyone at NECA can certainly reach out to us free of charge to talk about all these issues. And we'd love to continue our assistance and support of the organization. So if you have any questions now or later, please feel free to reach out to us.
All right, and thank you. Monica, I'm going to turn it over to you.
Thank you, everyone, for attending today. Some were not able to respond to my raise hand prompt. You may be having difficulty finding it, but thank you, everyone. Thank you, George and John. We look forward to more webinars with you. And please contact them, like they said, if you have any questions. Thank you, everyone.
Thank you, Monica. Everyone be safe. Take care. Bye-bye.